I'm being very, very frank. You are asking us to try a curative petition like a suit.
No, certainly. We have, not certainly, with great respect. Well, that could be one. Something which could not happen. So why I want you to place this letter?
You're absolutely right. Therefore, it says Government of India, that's how.
I understand.
You acted on a premise for a quarter of a century. Now you say you should have acted differently. If you wanted to act differently, you still can make available wherever compensation more you want to give. But you are trying to parcel it on the other side today. The problem, sir. Nobody prohibits the Government of India from taking a more proactive approach and say, look, we feel that the people must get so much more. Do it. Nobody stops it. Sure, can you fix it on them?
I could see that. But why I want to place a letter to just clarify certain lingering doubts which had come, and then how.
No, and then if you see the number of compensation, how many cases have been rejected? Do we take it that you wrongly rejected all?
That's another aspect of the matter. I only want to put it to your lordship.
So, Tony, there are difficulties in accepting this letter. This is a letter, a perspective of a particular person. Whether it was acted upon, what was the decision taken? Because it certainly says, as far as 36 wards are concerned, mere presence is enough. So that was the criteria adopted. Mere presence is itself enough. 20 wards, certainly no compensation. And neither it's your claim that for 20 wards in this curative petition that compensation should be paid. That too after 40 years. That's not your case. I don't think that's the case.
I'm not traveling beyond.
Yes, that's not your case. This letter probably reflects the point of view of the elected members of the person who's also probably a minister.
Wanted to place this letter.
That's fine. That's fine.
There's a certain reason that.
Attorney, what was the decision taken on the letter?
No, we stand committed by the curative petition claims, and that we are not.
I'm just saying you have placed this letter. Now, what
only to show that.
In that stage, what is the decision taken? Are we going to? How do we reopen everything?
No, I'm not.
The remaking process. We say no, because different dispensations remained in power at different points of time. Everybody had his own perspective of how this issue was to be addressed, this tragedy was to be addressed.
For a very limited purpose, I placed this letter only to show that the concerns of the state government and the central government for a long period of time about how do we really address this question in order that a person who may have a just claim is not arbitrarily excluded. That was the concern which is behind this letter.
As of 2010, this concern never found favor.
No, that's a different issue.
I'm not trying to favor 20 years after that, nor after that.
No, please look at the concern underlying this letter. So whatever might have happened,
we take it that Government of India did not act upon this request.
No, that the curative petition came to file.
No.
In the wake of this,
Mr. Tony, let's be very clear. This letter is for the other 20 wards which were not covered. And I do not think it's the stand of the Government of India that subsequently after 2010, those 20 wards are also covered. And that too after 2000.
I clarified that. The paragraph where the letter says in 1985, 36 or 30 plus 6 wards, the mere presence, etc., were the criteria adopted only to clarify that position, because your lordship put me the issue about those minor injuries, how it became so, and all that. It's by application of this criteria that minor injuries number came to be.
Actually, mere presence was given benefit irrespective of any injury over large areas. Nobody doubts that the right to give that compensation. No. Tomorrow you may say, well, that air traveled much more beyond Bhopal also. We would like to give a peripheral area also benefit.
There are two dimensions.
There must be a directness to the thing to fasten the liability of the tort fees.
There are two dimensions here. When the mere presence for a certain number of others who have been subjected to other kind of medical disabilities, like permanent disability, all that have been gone through. This letter says 36 wards. The wards were so severely affected by the gas leak. So how do we now draw an artificial line between municipal wards? how did the gas leak travel and ended up 36 watts? That was the concern behind
What I'm
it.
putting, so the
Therefore, just give it in.
the-
That's all I want to say.
the Honorable Minister talks about Bhopal as a whole place, give everybody.
That could be
That may have gone. Then somebody may say, well, we should not have confined it to Bhopal alone. We should have traced out where the air went.
That's right.
Therefore, all that.
I'm not getting into the larger question. I only want to say,
And in fact, going by your arguments, government should have granted the relief. Central government was not prohibited from doing that at that time. They could have granted the relief at that time.
provide
On the basis of this.
provided.
All the state government then in power should have
No,
deployed funds to provide
in
it.
the government of India. I'm just asking.
I'm saying that
I'm sorry. I
there were different dispensations and power at that stage.
I would only turn the court. That issue, all
So
those
there are
issues
different
are different.
dispensation. Everybody writes according to what their view is. When you are in power, you are not in power.
My only reason to write letter is for a very limited purpose. I'm not entering the question whether what government of India should have done at a point of time is not really something which is being canvassed here. What I'm trying to say is in 85, if the government took a stand that 36 watts will be treated as watts for the purpose of whether we are present or other injuries, that's the only limited purpose I want to place the letter. Now, whether what government should have done or not is not what I'm trying to enter into a debate. With great
There will
respect.
always be historical analysis of things even after 100 years. Question is, that is analysis, what ought to have been done, could have been done, perspectives, not what we are.
Yeah, they may not necessarily enter into the ultimate decision which the lordships make. But I just want to flag it, saying that if there is a question which has remained unanswered, I said yes, this is how it has happened. So that's limited purpose. So kindly, I will probably tell you lordships that the curative petition is I'll hand over 2 sets of notes. One, a note prepared by our friend Divanji, and I've also prepared a detailed set of submissions. I got permission, I'll try to read. But before I do that, we read yesterday the judgment of the court of May 18, 19. We may like to revisit the judgment. And then the Hura judgment, etc.
Issue is, you pay more. That's all. We are not concerned that they are not liable to pay. That's not the issue.
Please, Mr. Attorney, just one question. One question.
I'm sorry.
All these facts, a word in the play, consciously, when it came before, in interim order, it came before this court, where this decision was taken, that this much amount to the extent be paid on the basis of all these facts. Then the review came to be filed, decided in 1991. After deciding, these facts were on record at the 11th point of time. After deciding that review, unlike the government has not come in a curative, and now in a curative after 19 years. So now the relevance of these facts or reconsideration in a curative made by a government is an issue here which we are discussing.
Your Lordship, please.
So these points were there at the 11th point of time when the decision was taken of 470 pounds. So these facts were there. We are not denying that this tragedy was there.
Why I want to go back to it, only to say that the framework for a larger framework which needs to be presented to the court and connecting the dots. I'm going to connect the dots. Every dot is relevant in the sense that we're going back in the year 1991 or 89. But after 18 and 91, more dots have occurred. They were merged. How do I really connect them? Therefore, for the purpose of connecting the dots, I'm trying to say these are the pleadings, and the pleadings were certainly the knowledge of the court, and they were canvassed in a reasonably way before the courts. But regardless of those facts being before the court, on a certain assumption, that's why the order in May 1898 says, on a certain assumption, we are endorsing the settlement. We are all trying to say the assumptions are no longer valid and relevant and final. So assumptions have gone.
See, the whole problem, the moment you say those assumptions are not, are you opening the whole thing?
I'll come back to it.
You
Of
can't
course,
say,
in a manner of speaking.
it's not, we are going again, I'm sorry, round and round and round.
I'm sorry.
Because the point is, you are saying, well, we did settle at a particular value. We did take those monies at a particular value. Now, Their argument is, are you opening the whole thing? You say rightly, no, we are not opening the whole thing. We are saying you are liable. You accepted liability, accept more liability. If the willing, there was no point problem. But they are saying, no, this is the end of our liability because both sides choose to bring the liability to an end. Given that scenario, and as you put it in the plaint, looking to all future scenarios also. You are conscious that you are, in as per the plaint, looking to all future scenarios, putting all those future scenarios to an end by entering into a settlement. And you chose to enter in settlement, not under any duress, not under any pressure. That's nobody's case, can't be, with the mighty Union of India at the one end. Therefore,
No, why? I know there's a certain element of repetitiveness about it.
no, it's not repetition. I'm
But,
just saying that we will ultimately, at a curative level, what this claim
I'll come back to it. I'll immediately come.
I honestly don't think this is all relevant. So what we have to come to is, you are telling us that there is some very innovative path which this court must follow, despite the curative defined contours. Please show us somewhere where it has been done. Then only can we appreciate it.
I'll do
Where
that.
has it been done?
I'll immediately do that. I'll take the losses to the Hurrah judgment. Before that, there are some passages from the review judgment. I'll try to read that out and then go into the Hurrah issue. Well, I thought some of this little.
So what you're propounding is that the matter was left at that stage based upon the facts and figures,
Yes.
and it was open to the parties to move in accordance with law in case those facts and figures change.
Yes.
That's your best argument you can.
Yes.
That's therefore you're not saying that the settlement should be revoked. You say please enhance the sum in the settlement.
That's right. I started with the proposition.
We have
Right.
understood that, but the difficulty which comes about is that the facts and figures are virtually known to you at that time. And number one. Number two, if the facts and figures subsequently set out in the affidavit filed by you in response later on when the dispersal of the additional amount is also made, is indicative that as far as serious cases is concerned, they have been adequately and fairly compensated. That you're not disputing. They have been adequately and fairly compensated. The real difficulty which is coming up is those cases which were classified by you in minor injuries. There again, they have been compensated, but the formula which you're trying to apply is whatever was paid, that should be kept static at that point of time, where the number of people specified in the order, which is not correct for the simple reason that even the persons who had died, of course, that number increased, but the number of people who had permanent disability decreased. Number of people who had temporary disabilities also, there was a slight increase. But as far as number of pieces, at most severe cases, there was a decrease. So there has been some increase and decrease. So that was always inbuilt into it. The real issue, really what has happened is this 955 crores. And to say then the formula which you are adopting, there can be hundreds of other formulas to justify that there's no increase required. Because ultimately the fact of the matter is they have been not only compensated in death cases by 10, but probably 20 lakhs. That's a fact.
Right. But I was trying to point out because
And
what is
let me add,
something
your plaint reading shows that you had the present in mind, you had the future in mind, you had unknown possibilities of future in mind when you framed the claim. Therefore, when you settle with all those possibilities, all those known unknown quantities, known unknown possibilities, and said this is where we put to it. So the fact that you have a more comprehensive plaint drawn up, looking to all and absolute, all possible scenarios. Your settlement is not that something. May I say this? It creates a greater difficulty in your way.
May I say
Because the plaint is very, very widely worded,
and rightly so.
Absolutely. But then the answer would be rightly so to settle it.
May I say that?
And therefore we said, if you feel that they are entitled to be paid more, please pay them. There's no difficulty. Question is what we should do in curative petition.
I just come.
If they are entitled to more,
Yeah.
as paragraph 198 says, please pay them. Question is what we should do in curative. That's the only question. Pay them. That will be most welcome to do.
No,
Pay them.
before your lordship asked this question, There are some of the questions that are raised and answered in the review. Once I read them, this question probably will be answered. I was responding to that.
If you were as a welfare society so concerned you wanted to pay more, you should have paid more. It's not a question you paid more.
If the Union of India was the delict, all these questions would have been answered against Union of India.
No.
With somebody else in the delict.
Absolutely no. Absolutely no. You as a welfare state adopt a different principle whatsoever, whether you are liable or not.
You're also putting to me a question.
No, I'm saying, is it that I don't want to pay, but I think I can get it from you? This is what
It's not a question. It's not a question of why I want to pay or not to pay. The question is who should bear the liability to pay?
Have you paid?
Therefore, I said UCC is the liability to pay.
Have you paid that
Unless
extra?
that question. I'm so sorry.
Have you
Unless-
paid that extra?
I know that question.
You
will be
want to
answered.
absolve yourself of a welfare state principle and say, no, I want to take it from them, rather than when, if I take it from them, I'll pay.
So we have
So
paid
what is
in
happening?
2010 ex gratia. We have done that to the extent that Government of India should discharge their responsibility. So the welfare state coming in is an entirely different direction. Wholly unconnected to the question of UCC's liability. I would very humbly urge that question ought not to be linked to the question of the welfare state's intervention to undo the miseries of the victims. That's an entirely different link altogether. So then, why I was trying to bring this is in a very ordinary court. Was put to me why you had put it very widely in the plaint.
What is pointed
When
out?
we put it in the plaint, and I'm sorry.
No, no,
I'm so sorry.
Sorry. You see what the ex gratia amount you certainly paid. There's no doubt about it. But the ex gratia, the amount deposited because of various fortuitous circumstances, maybe depreciation, value of the rupee or interest thereon, was sufficient to meet that. What you have paid is 740 crores. You paid 740 crores, and the amount and figure which was ultimately available, was about 3,000 crores with interest and the depreciation value of rupee. So that was sufficient, because what you have actually paid, let's be very clear. What you've actually paid is, even if we take the three figures together, that is 525, 675 and 740, it will still not. In fact, what you have paid is 675 and 725 and 740, which means about 1,500 odd, and you have paid 1,509 again. So you have compensated them. Yes, we have to account for that, because if the figures were fixed at the beginning, you have to
Yes.
account for the interest part.
Yes.
You have to account for the interest part. Unfortunately, the payment was not made accounting for the interest part.
No, that's why it told us yesterday. It relates to 1 lakh people.
Whatever you had, you paid. Whatever was due, you paid. Whatever more money was available, so you paid. Now, fortuitously, even after making payment, all those amounts, 50 crores is lying. That's what is the ground reality.
No, but may not be fortuitously.
So, fortuitous
Kindly, in the same law,
fortuitous circumstance in terms of, suppose the dollar rate had declined, different scenario would have happened.
I would very humbly urge of your lordship. That's why I place this figure of 3 billion, which they ought to have brought to this court, and will be 52,000 crores. Don't please look at 3,000 crores exchange rate.
How can we not look at it?
Because
How can we not look at it?
rupee
You settled for it. We did not settle for it. You settled for it.
rupee devaluation. Who could have controlled it?
Absolutely. Therefore, when I use fortuitous, you say no. It is a fortuitous circumstance that the amount which was lesser grew because of devaluation of the rupee.
Even if I take it like that, it's in a manner of speaking, please don't look at the windfall gain for the victims. It is something, a pittance which they have got now.
It's not a win. See,
Therefore,
going
it's a
here,
windfall.
Ravi.
It is not
It's not a question of windfall gain.
Yes.
It's not a gain for the victim. It is giving you a larger corpus by reason of this scenario to satisfy claims of the claimants. That's what has happened.
Right,
Because in Indian rupees, that amount has grown larger. Therefore, you are in a better position to satisfy claims. Otherwise, the 1,500 extra would not have been there.
Then
Then you would have been settling for 1,500 crore.
The Union of India could have simply asked this question. I had a larger corpus on my hand by reason of all the intervening events and circumstances. Therefore, why should I look into the need for an additional compensation? Why should I look into that need? The need arises because the number and the assumptions have gone wrong.
Attorney,
That is the need.
we are conscious of that fact. We have all the sympathies for those who have suffered. If they need be, they should be paid more. ultimately you have to fit in the conspicuous of curative petition.
I'll come to that.
Within 4 corners of Quran
I'll
judgment.
immediately
That's
come
what we are repeatedly telling you.
I'll immediately come to that. But these are some
I
broad.
began by saying the Maryada of the jurisdiction, and I stick by that. And you accepted that. Every jurisdiction, we are not somewhere.
Is there
We cannot be please understand, the courts can't be, I always said, a knight in a shining armor, moving around and finding Paresha for all the things. Not possible. We are constrained by law, have some leeway.
Of course, you're also constrained by law.
Of course, we have certain leeways.
But
And that also as the apex court we have it. But we can't say that we will decide a curative petition on the basis of jurisdiction of a original suit. Mine is any evidence?
Is the Union of India asking the lordships to enter into the curative engagement on any
Like a suit.
abstract proposition?
I'm being very, very frank. You are asking us to try a curative petition like a suit.
No, certainly. We have, not certainly, with great respect. Well, that could be one possible perspective, but with great respect.
Certainly, we will not do it. You do
No,
whatever.
No,
You can't make us do say we are in a curative petition. Now we'll produce documents. We'll do this. Please convert this into a civil suit.
No,
Here.
what have I?
And
What have
reopen the settlement. Keep that settlement bits of their side on, and try the suit now. Carry on the whole trial of the suit here.
No. There's no.
What is happening effectively?
With great respect.
This is the net result is this only. There's nothing else in this.
It may, in terms of form, it may look like that, but in substance, it is not. Because in substance, it is not. So if the curative petition is based on the culmination of the Welfare Commission's determinations, and that's what was retained as inherent possibility both in the review judgment, because that kept it open. The review judgment kept this adjudicated process open, and open for valid and good reasons. If that was kept open, and that has now emerged in a certain set of figures, I only ask you to look at when the review judgment came, you said, yay.
Let's come to the brass tacks. Let's turn to the judgment which you are wanting to say, and the curative where you draw strength. Let us turn to that. I think we have had enough of facts. We understand it. We are unwilling to. I've said so repeatedly. There's no point in our repeating it, and collectively we are unwilling to convert this curative into a suit. So please don't, which we believe is the path which is being traversed. Let us come to on what basis you seek to expand the curative.